this working session on how to file a criminal complaint with Douglas William Heisel, acting governor of California State Republic Trust, and Madison Marquette. Go ahead, gang.
Okay, so we're just going to start and then Doug can intervene here because we've been filing these criminal complaints, but there's questions here. And then Kathleen, if you have any questions for us, just cut us off and ask us. So the first question is who is the criminal complaint being sent to? So an AO91 criminal complaint is being sent to the district U.S. attorney that's in your district in your court. So, and make sure you know what district. If you're not sure, call the court and ask them what district you're in, because when you do the AO91 complaint and you look up at the top, it'll show all of the districts and you have to scroll down. They will not accept it if you do not have the right district. And I actually learned that the hard way. And a lady on the civil side told me. So it's going to go to the U.S. attorney. Then it is going to go to JAG. And I need to look up who it's the head of JAG is who you would send it to. And I can look that up real quick, who that is. And then the next person you're sending it to is the Department of Justice Civil Rights Division. And
all the addresses we need, right? Where do we get those?
So the Department of Civil Rights Division, you can just Google the Department of Justice Civil Rights Division, and it shows you there an address of where to send it to. And I'm looking it up right now.
I think I have those, Madison, and I will post those in the chat. So while you continue talking, give me a moment and I'll try to get those posted.
Perfect. I had sent it out to the task force when I sent out Andy's complaint, and I put it in there. The only thing that's not added is the district that whoever is in. Defendants, JAG, Trump Special AG. What is that question? Are you asking if you're supposed to send it to Trump?
Yeah, I'm asking, so you're sending it to JAG, we need an address for that. You said we're sending it to the Department of Justice Civil Rights Division, we need an address for that. And then I believe the district court for me is a Southern District here in San Diego. And yes. So there's an AG there. Is there only one? Like who, or I look up that name somewhere?
Well, it's not the Attorney General. You're not sending it to the Attorney General. You're sending it to the U.S. Attorney in your district.
It's the U.S. Attorney in the Southern District, at the head of the criminal division.
Head of criminal division. And then the other part of that is, do I send any copies to the defendants or just these 3 locations?
Depends on how bad you want to piss them off.
See, that's what Doug says is I like to piss them off. I actually go file it on the public record.
I'm sorry.
I said I like to piss them off. Doug said it depends on how much you want to piss them off if you want to send it to them. I like to piss them off even more, and I go down to the court and the district that it's in, and I go to the clerk of court and I say I want to file this on the public record, and then they'll give me a hard time. I said I'm willing to pay, the fee, and I want a certified copy, and I post the certified copy on the public record. You do not have to do that. It's just something that you can do.
Okay, and this is going to my banker and his attorney and the people that think they've bought this house in foreclosure and their attorney. So I'm listing them all on there. And if I send a copy to them, or you're just saying by publishing it on the record, that is notifying them?
These are criminal complaints. You don't have to notify them of the criminal complaint. Doug was saying is if you want to piss them off, then send them a criminal complaint. I just go the extra step because I'm sick of dealing with the criminals.
Okay, I'm thinking if I send them copies of this, that might slow their roll.
Yeah.
Where do you laugh for, Doug?
Well,
okay, how do you get their personal address, mailing address? So there are different background forums that you guys can sign up for and pay for. Some have like you can pay for 14 days or something like that. So you can just look up, a background, and then you type in their name and different things. I have more of a professional one just because of my job, but that is available to the public. And then when you look at it, you can look at to see what their assets are, what their personal addresses are, because eventually, if you're sending them a notice of liability and doing the other side of it, you're going to want to file liens on their personal property.
So
And-
let's
I like
like that.
just think Madison. So
Doug,
No.
can you come closer? Can't hear you.
I said I like kicking off shit just like you do. Yeah, so when you send them a criminal complaint, it arrives at their personal address. It
Doug,
lets
I
them,
can't hear you at all.
Hey, Doug, I wonder if you go off video, it might help the bandwidth. Sometimes being on video makes it so that it's not as clear. That might be
You
something
want
to
me to pause
try.
video?
can you hear me now?
No.
No.
a little garbled. I can hear you, but kind of come and go.
Oh shit. I don't know.
Yeah, we can hear you.
I can hear you.
Try it again, Doug.
You can hear me?
Yep.
Yeah.
Okay. When you send them a criminal complaint, right, to their home address, and they get it at their home address, a lot of these people think that they're untouchable, that nobody can get their address, that people don't know where they're at. So
Mhm.
when something shows up at their home address, then they know that you and everybody else that's got copies of this know where they live. You know what I mean? And this is
Yeah.
what some crazy person might do. So that scares them.
Yeah, that's what I want to do. And then I also have a whole nother case with the sheriffs here, the jail, the highway patrol. They arrested me and my husband, put us in jail for 12 hours for rolling through a stop sign. So I have the
California stop.
officers with their last name and their badge number, but because I did a FOIA for that, but I don't have any. How would you go to a background company and just with a last name and an initial and the badge number? Like, I know that's not part of this one, but I have more to do. So I'm just wondering how I acquire this information to send
So
stuff.
you could put in their last name and their city, and it'll show like,
I don't even know that.
but the
city.
city where they pulled you over, I would just put that in
Oh, okay.
because they worked there, and then it would come up with some different people, and it would show where they work, and it would show if they were a sheriff or a police officer or policy enforcement officer or whatever.
Well, I know
And
which they are. I just don't know how I would find their personal address again to send it. And you say a background company. Do you have any names or something I could?
so there's like Intellis, there's Truth Finder. I'm trying to think of if you look like top 5 background companies, and then you can pay to put in their like for a certain amount of days and put their name in it, and then it'll come up. Like you could put their last name, and then the city. And like the way you see if it's them is you can go and look, okay, businesses or licenses or anything, and then you will scroll down to assets. It all is outlined pretty nicely in some of these background. Mine's a little bit more intense, like I said, for my job, but if you ever want to go and do some things on the side, these are actually pretty good ones to go do. Just know, like, if they'll charge you over and over and over again. So you just want to make sure, like, you have to cancel, look at the way you want to cancel. But I think it's a good tool to have no matter what, because we're all fighting the system. So paying to them doesn't seem like that big a deal, So, okay. Or do I send to their place of employment? Doug, I think they should send to both, right? Or what do you think?
Well, it all depends. It all depends on the charges and everything else. If the charges have to do with their employment, then you want to send it to their employer, because your next thing is holding the employer responsible because there's misprision of whatever felony that they're committing if they don't do something about it. So I mean, there's a lot of ways of tying these people up. Like you know, I, you know, I like to send it to everybody above them, you know.
Okay, so
Right.
when I do my other case with the sheriff, I'm gonna start with him and the list of his employees that were involved in all this crap, and then,
Well, if you're gonna
for the people, I think I should send it directly to their house.
if you're gonna start with the sheriff and all of them, what you do is you send everything to their house. That lets them know that everybody knows where they live
Yeah,
and scared them, okay? Because that's a security issue with you because they know they're pieces of shit. Cut their head.
exactly.
So, and what you do is you get at the attorney general and you get the office of inspector general and all of
Doug,
that.
it's really hard to hear you.
Look, I don't know.
We can hear the sound, you just kind of are garbled occasionally.
That's this website, you know, because my computer's everything's plugged in right. I don't have any problem. There's no problem. The microphone button isn't blinking or anything.
Mm-hmm. Yeah, we can hear that now. Okay.
What were you saying about the attorney general?
Yeah, I would because they're law enforcement. Okay, generals are responsible for all of the law enforcement, just like the inspector general is the one that's tasked with investigating them. So when you put a criminal complaint before them, sworn under penalty of perjury, you know shit rolls downhill. What you're doing is you're making the people that are above them liable if they don't do anything about it under misprision of a felony. See,
Okay,
they have a duty under 18 U.S.C. 4 to report the crime to the nearest investigating agency that's not involved in the crime. So, you know, whoever you're sending it to, if they're an attorney general, they've got an oath. They have a fiduciary duty to do that. So when they don't do it, it becomes an emoluments violation because we're paying them to execute the duties of their office. And they're taking the money to execute the duties of their office, but they're not doing it. So that's an emoluments violation. So I said, I mean, you can go out right on down the line. What I like to do is I like to lay everything out. And I talked to a friend of mine, Charlie, this morning, uh, about the mortgage stuff because I was telling him what I was doing and fixing to do on the mortgages. There's 7 things that I've got a list somewhere around here. I have to get rules and or I'll get Charlie to give it to me again. But there's 7 things that are required for there to be a valid mortgage or a valid debt. Okay. So what Charlie does is does an affidavit of
You know what I'm wondering? Well, can we try something? This is Michelle. Doug, when you're talking, Kathleen and Madison, would you mind going on mute just to see if that changes the garbled? I'm not sure if that will help or not, but if we could do a little test.
it's probably the CIA motherfuckers on the
It's on mute.
goddamn thing like they've been on our shit. They turn our stuff down and they turn our stuff down, hang up on us. Ain't that right, Madison? But
I don't think him and I have ever had a conversation where it's not hung up 20 million times, or he sounds like what he sounds like right now.
yeah,
We're on every list to known to mankind, so they don't want us talking.
yeah. But what he does is he does an affidavit of no loan, an affidavit that there was never a loan. Okay, because for there to be a loan, there has to be a contract. Okay, so you have to have a contract, and then there's something of substance has to be given to you that you take full custody, care, and control of before you owe anything. And on a contract, there has to be 2 signatures, and they never make a contract with you. There's never 2 signatures what they do is they con you into producing a promissory note when you haven't received anything. Okay, you never took full care and custody or control over it, right? And then the fact that you didn't get anything and you did a promissory note, right? That's fraud. There was never a loan for you to owe anything to do a promissory note. Why are you promising to pay somebody back when you never got anything? See? And so when you do a criminal complaint on a fraud and put that affidavit in there, they can't rebut that affidavit. They can't come in and show, hey, there was a loan. Here's two wet ink signatures where they agreed, and there's a meeting of the minds. And no, there is no contract. There is no something, a substance that was of theirs that was given to you for you to owe them. Yet you did a promissory note. Okay, so that became a unilateral contract, and there's no such thing. So, what he's doing is he's doing an affidavit of no loan, okay, and then doing a criminal complaint, documenting the fraud and everything else after that, and then sending that to the mortgage company and filing it in the county and sending it to a couple of other places, right? And there's nowhere for them to go. There is no loan, there is no contract, there is nothing. Then the next thing is to try to recover everything that you paid in on that so-called mortgage because it was fraud. But right now it's kind of hard because you never really paid anything in, except sweat equity, because there is no money. See, but that's the way that he's going about it. Um, Me, I like to do a notice of liability because these people are required to know the law. And so, they should know that a contract's required and it has something of substance has to be passed and all of this, right? And so they should know it's fraud. They're required to know it's fraud. They're supposed to be professional corporations and they're given the opportunity to monetize credit. See, that's what they're doing is they're coming in and they're taking your promissory note, and the reason that they can't give you the original back is because the bank has it. They put it with whatever financial institution that they're working with in this fraud, and once they deposit it in a transaction account in your name, they withdraw the credit, the monetized credit from that account and put it in a check and give it to the seller, all right, and or escrow or whatever, and you never even touch it, so you never take full custody and control and care over anything. So it's fraud from the gate. It's constructive fraud from the gate. So once you put that in their lap, I would send it to the attorney general and I would send it to a few other people, right, like Charlie does. Once you make the crimes known, then they have to do something about it or you can go after them. And that's what you call leverage. Nobody wants to be liable. So when you go in and you show the mortgage company through an affidavit under penalty of perjury, right, and then file a criminal complaint as an injured party using the same statement of facts and affidavit that you used to say that you didn't get a loan, there's no way that they can come back in and rebut with evidence that you got a loan. They always try to bring a copy of the uh, promissory note forward. Okay, what the fuck is that? I wipe my ass with that thing, except it's got sharp edges. You know, so it's not a contract. Where's the two signatures on it? Where's the contract that goes with it with the two signatures on it? You see what I'm saying? They don't have that, so they don't have the stuff to actually rebut that they say that there was a loan. You know what I mean? It's all constructive fraud. It goes back to when they took the substance from our money under House Joint Resolution 192 and Public Law 7310. That was an unauthorized act of Congress. And to translate that, I mean, it was unconstitutional. They never had the power or delegated authority to do that. and they did it anyway. And what they did was they allowed themselves to operate in a voluntary bankruptcy. It's not like they were taken into bankruptcy and it was given to a trustee. No, what they did was they came in and they allowed themselves to operate in a voluntary bankruptcy. But part of the agreement was to do this is they couldn't reject any of the people's claims. Okay, they've been rejecting all of our claims. They've been acting like we don't know what you're talking about. They were supposed to take care of. He who has the gold pays the debts. They were supposed to take care of everything from us, and that's what the birth certificate and social security account were for. That was for us to discharge debts, to accept for value in return for discharge, telling them using the exemption number, which is your social security without dashes, letting them know that here's where you go to get paid. And so, that's the way it was supposed to work. But what they did was they decided not to tell us about that part of the New Deal, and they used us as cashes to run their dirty money, launder their money through our accounts. And then, when it came time for us to be able to discharge stuff, unless you really, really knew what you were doing, you wouldn't see it. They'd act like we don't know what you're talking about. You know what I mean? So it's all constructive fraud, but that's where the constructive fraud goes from. They took the substance of our money and they created a fraudulent system to be able to just use fiat and commercial instruments instead of money to either discharge or transfer debt and stuff. So that whole system's constructive fraud, including the court system. The court system you're involved in is constructive fraud too, because what they're doing is they're taking bonds out on you guys. Okay, they take out the bonds and then they invest them in the court registry investment system, and then they hold you as collateral. Okay, for however long they get you for, whatever sentence or what have you. Plus, it's Roman civil law and it's being enforced by bills of attainder and bills of pains and penalties. You can't have something that tells you what the fine's going to be and how much time you're going to do in a republic when you haven't gone before a jury. Only the jury can decide that and say what it's going to be. So all the rest of this is basically it's constructive fraud, and it's constructed on the fact there's no money, so it's a do what you want system.
Okay, Doug, so there's some other questions. Do I need to hire a skip, trace, or recommendations or suggestions? Here's my,
For that, but yeah.
I don't, I don't, I don't think you should hire one because I hired one in a case that I'm working and they totally screwed me over. And they actually had a marshal call me and tell me that I was, what did he say to me, Doug? Basically that I was like delusional, no bonds, or he told me I was a conspiracy theorist. And I said, you're right, I am. That means conspiracy needs to conspire. And yes, they are conspiring against us. So yes, 110%, I'm a conspiracy theorist. And I said, and I go, you're not a legit marshal because US Marshals will tell you the truth and you're not telling the truth about the bonds. So, and these PI, a lot of these PI firms or skip tracers, every single one of them are former law enforcement. They are not going to help you. They're just going to take your money and run. So it's easier to go onto these background sites and find their assets than it is to hire someone to do it. There's just no point. You're wasting your money.
Either that or find somebody that has access to the, what is it, clutch system, or there's another one that peace officers and those have access to that. And you run them and come back with all of their assets and everything like said. That's the best way.
Yeah, I don't know what that website is. They all have to upload, and I've been looking, but I think everyone, we should all start doing this. Is what Doug was saying is you can go look up and see their assets have to be listed for public servants. Their assets have to be listed. in
Yeah, they
certain
got a form.
places.
I don't know if it's a 407 or what. They got a form that they have to fill out that lists all their assets so that it can be checked to see if there's any conflict of interest or anything else. If there might be some problem that might come up because they're holding assets to a corporation that does a lot of stuff that's dirty, and I mean, it's just they have to have it on a piece of paper, and also it's also for us because we have a reciprocal lien right. All right, so it's like they charge us so-called taxes for their services that they supposedly perform. That's what pays them. Okay, and so if we don't pay our taxes or we don't pay for their services, they can come fine us, if he is, tax us, even worse. And then if we still don't pay them, they can put a lien and actually attach and take our personal and private property and sell it to recoup what they think that we owe for services. Well, if their services aren't forthcoming or they're lacking, let's say, we have a reciprocal lien right against them, and we can place all of their personal property on a lien as collateral for any damage, injuries, and damages that we've received through their misfeasance, malfeasance, and nonfeasance. So it goes both ways, and they have a sheet that lists everything that they have, so that you can get there and find that sheet and utilize that to calculate the collateral for the injuries and damages that they owe you.
Okay, so Kathleen, maybe you can tell us what you're trying to ask. Are you asking if you're supposed to include points and authorities? Is that what you're asking?
Yes. Yeah, I have your copy. Thank you guys, by the way, of Andy's points and authorities. So my question is, on my points and authorities, I'm including that with this complaint. Is that correct? And do I
Yes.
need to have it to swear to it or have it notarized? My points and authorities? Do I
You have
just
to swear to everything, but here's what you do. You use your statement of facts, okay? And this is important. You take your statement of facts, and that's what you swear to under the penalty of perjury, okay? So it goes down when you do your statement of facts, you actually put that into it. And I swear to the statement of facts in this document under the penalty of perjury. So the only thing you're swearing to under penalty of perjury is those statement of facts, because that's all you can swear to under penalty of perjury. Everything else, there's some gray area that you may or may not know for a fact. Some of it may be conjecture, some of it may be feeling or what have you, right? So once you have those statement of facts, the best thing to do is when the shit's happening, either record it or go through and right afterwards list all of the facts while they're fresh in your mind. Okay. And you take those statement of facts and in the process that we use, you use the same statement of facts through all three processes, through the notice of liability and opportunity to cure, through the criminal complaint, and through the tort. Because the facts never change. If they change, then there's a problem. Okay? So you take those facts that are sworn to under penalty of perjury. Your argument is how those facts and the occurrence of those facts constitute the crimes that you're claiming have been perpetrated against you. And then you use, I like to use like the Constitution, the foundational documents, maxims of law, because that's real law, right? Uh, Things out of the law of nations, uh,
as
and I
authorities,
watch,
Doug,
I watch a lot of Kirk Slifer, and because he goes through and he'll tell you exactly where the stuff comes from, and you can go look it up. So it saves me a whole bunch of a bunch of trouble. Dude is good at his research, right? So what I do is I go and I look up the source, right, of that law, and I utilize the source of that law And then I tell them, I say, even your private corporate policies and your codes and statutes recognize this behavior as criminal. And then I list their statutes that show that that behavior is criminal. So I don't use their crap as authority. I use the real law as the authority, which they're bound by, but they're also bound by their statutes because it's their corporation and they've sworn an oath, and their corporation, they're bound by the behavior is dictated in their operational procedures and everything else. So it only affects them, but if it holds them to a criminal liability, then I would throw that out there to show that even their own codes and statutes and private corporate policies uh, recognize these actions as criminal. Then there's no way they can really argue that, especially if you go from the source down to their source. You know what I mean? And so you're arguing how all of this stuff fits together and their actions have violated these rights and these maxims of law and even their own code, statutes, and private corporate policies recognize this is criminal behavior and they're bound by that. So they've reached their fiduciary duty to act in a certain manner towards one of the beneficiaries, me. You see, that's how I lay this stuff out. And they can't argue or rebut it. And if you don't rebut, you admit.
Okay, did you have a question before I go on to the next question, Kathleen?
Were you referring to the authorities there that you're using in your points and authorities? Doug? Is that what you're talking about right there? Or are you saying in the statement of fact you put those down?
No, your argument, your statement of facts are just the facts. You know what I mean? On such and such a day, at a certain time, Officer No Nuts pulled me over and asked to see my wallet. I gave my wallet to Officer No Nuts and he inspected it. And as he inspected it, he removed $250. I asked Officer No Nuts for the $250 and he told me that it was a fine for my speeding or whatever. Okay, those are the facts. Okay, by Officer No Nuts asking me for my wallet without a warrant, he violated my Fourth Amendment right. Okay, by Officer No Nuts opening my wallet and removing $250, he performed armed robbery against me because he had a firearm on his side, and I was in fear of being shot if I told him he couldn't have it. By Officer No Nuts telling me that it amounted to a fine for whatever behavior I had exhibited, places Officer No Nuts in the business of extortion, highway robbery, piracy. See, I can take those three statements of facts, but I can turn it into all kinds of shit by the argument, and then I can use the points and authorities to lock it in. You know what I mean? That makes sense.
That makes sense. Okay,
Yeah.
so the next question, it says, does each copy need to be an original or one original can be copied? So, and Doug, you can correct me if I'm wrong when I say this, but you need to always have the original copy in your hand. I always have the original copy. I also, at the end of it, when I sign my name, I have a red stamp pad, take my red thumbprint and I put it over it. I also, when I go to the post office, I cancel out the stamps. Even if I send it certified mail, I add the stamps and cancel it out. But you always want to have the original copy, right? Because that, what, how do you explain it?
You never give up the originals on anything.
Yeah, I'm clear on that. I'm just wondering if I'm sending it to JAG and I'm sending it to the head of the criminal department and I'm sending it to the Department of Justice and I'm sending it to each of the defendants.
Well, to JAG, Department of Justice, Civil Rights Division, and to the U.S. Attorney's Office, what I would do is I would take and make 3 copies, right? that I signed in red ink and put my thumbprint and all that on, and those are all originals. And then I would keep the original copy that I did that to, and I would write original across the top, right? And then I would take the other ones, and those are originals, but I wouldn't write original on them because you've dubbed yours as the original, right? I would send them to them because they have the wedding signatures and the original thumbprint on it. They can tell whether it's a copy or even that good laser shit look like a real ink thumbprint or ink signature. So they got what you're doing is you're giving them uh, everything that they need to actually move on this form. Okay, you're giving them a sworn statement by an injured victim with firsthand knowledge of what happened, a criminal complaint that's signed under the penalty of perjury and has the arrest warrants on the back of it for them. So they don't even have to do shit. Just go out, read it, investigate it, see if it's arrest them. And that's what these 700,000 indictments and all of this stuff is. That's how it got to be that much. Because everybody's starting to complain. They're starting to utilize this thing that Trump set up to be able to tell on these people and expose the corruption. And see, when you start getting into the misprison of felony, misprison of treason, misprison of this and that, our government is supposed to take care of all these pieces of shit. All right. Once they find out that there's something happening, that there's a crime or that they violated their oath, they're not supposed to be able to sit in that seat because that seat doesn't belong to them. That seat is a public trust that was created by the Republic. And I know these are corporations, right? But I don't give a shit about the corporations. They're not allowed to exist. Under the Clearfield Doctrine, they're not our government. And we're only allowed and guaranteed a Republican form of government. So what you have to do is look at this as a Republican form of government, and when they're not uh, acting in that manner, they're in breach of their fiduciary duty and breach of their fucking oath. So you hold them to the uh, you hold them to the requirements of a Republican government, what they're supposed to do, and don't let them argue that they're not a Republican form of government, or if they don't, or we don't know that, well, that's fine, because being required to know and knowing are considered to be the same thing. Ignorance of the law is no excuse.
So Doug, just to confirm then, I do 3 quote unquote originals to the big names I'm sending to, and then I can just send copies to the defendant.
You want to keep one, and then you do an original for each one of the agencies that you're sending it to, because I believe they'll only act on an original signature.
Okay, so to clarify then, 4 originals, 1 I keep for myself, the other
And
3
you
go
mark
out.
an original across the top with a red pen.
Okay, and then I can send copies.
Put your thumb by that, and then you can run copies off of that to serve these other peons.
Okay,
It's small.
okay, good.
The next question that these kind of all go hand in hand. How is it sent? Certified, return receipt, regular mail, size of envelope. So you always want to send it certified mail with the return receipt, and the envelope is going to depend on how big your statement. I mean, I think mine was, I think I had like 56 pages. Plus, I had the arrest warrants, plus the AO 91 criminal complaint. So mine was pretty big. And so I actually just asked the guy at my post office is a little original because he's like such a patriot and he knows what I'm doing. And he says some other girl comes in and does the same thing. And I'm like, please give her my card because I would love to talk to this lady. I don't know the post office can do that. So he knows like what to tell me, but I think it's going to depend on how big your actual criminal complaint is. But you definitely always want to have the certified mail and the return receipt.
Okay, and
It's like you can send it certified mail because that's service. But if you really want to be a stickler for something real important, you can go registered mail. because that's private hand-to-hand mail right there. And so that also registered mail, those numbers in registered mail are also protected. And so you bring in the authority of the Postmaster General.
Now, what about the copies I'm sending to these other yahoos? Do the same certified return receipt to them? Okay. And then back to the original.
You can also do it. What's that shit called where you can put it in that envelope and pay? I think it's pay $10.
The prepaid thing, kind of like what is that called? Priority mail.
There's a thing kind of tracking on it.
Priority mail.
Yeah, okay, priority mail.
Yeah.
I think it costs you $10. Put your envelope in this other envelope, and you send it that way. And you don't get a green receipt. You get on your receipt, you get a tracking number, so that it can all be tracked. And then just once a week or whatever, track it and print it off from the USPS.
Yeah, that's a good idea. And then you don't have to wait for them to sign it. Okay, and then back to that original thing. I'm thinking that this AO91 is the front of this package. Am I writing in red across the top of this? I know how these court things, they don't like stuff written on their little forms that don't go there. Do I write original red across the top of that?
You're not sending that to the court.
I'm not.
She's wanting to send it to piss them off, Doug. She wants to send it to the court to be like, hey, F you, I'm filing this criminal complaint.
No, I didn't. I'm just assuming that's what I'm doing, but I see that I'm sending it to these places.
You want to put the judge in it too, in the criminal complaint. You know, if you're going to do that and you're wanting to piss them off, you place the judge in it, and you have a few people from the task force send them too, so they got 3 complaints against that judge, and the judge can't be insured anymore.
Yeah, so Kathleen, when you're done with this, the whole point of this task force and anyone else that is watching is that you finish your criminal complaint and then you email it to me, and then I email it out to the task force, and 3 of us send out this criminal complaint. They're uninsurable. These judges, these attorneys, everything else, they get kicked off the bench just because there are 3 complaints within the year, and we're at the beginning of the year. We can do a lot of damage throughout America in the next few months if we get on it and get it completed and get it done. So the next question on here are defendants. Are these people and corporations they work for? Tell me what you're asking.
Okay, for instance, Craig Blunden, he's the president or the CEO of the bank that I'm going after. So do I put his name and his bank's name? Do I put his attorney's company name, or do I just put people? Am I putting entities or people here? Who are the defendants? Is it all of the
People?
Okay, so
You're
people.
dealing with people. These people are pretending, and Doug, you can correct me when I'm done here if I'm wrong, but they're pretending to have dominion over you, and they've created this constructive fraud. So you're addressing it to the people, and we don't work with attorneys. Did you contract with that attorney? I don't.
No, I mean the attorney that's coming after me, the bank's attorney that keeps sending me letters, and the attorney that represents the person who thinks they bought this in foreclosure. I'm putting them on here too, but I put their name, not their company.
Doug, doesn't she just address it straight to the not who does she address it to? It's the bank, right? It's the owner, not the attorney.
Yeah, it's the CEO.
I want to
the
CEO. Aren't I all on there?
Huh?
Aren't I putting all of them on there? They're all in construction.
That's who you send it to, because that person is responsible for the training and the curriculum and the loan processes at that institution. So, you know, you're sending it to them as the principal, and everybody else is one of his agents. There's your conspiracy and your chain conspiracy, because it requires each link in the chain for the conspiracy to go through. So that makes all of them liable for the same amount.
Right, so the defendants can be all these people. My main question is, I'm putting people, not corporations. Okay,
And if you want to address the attorney, you can say that the attorney is working off of constructive fraud themselves because they're saying they're a licensed attorney. You can put on there whatever, you're in California, you could say, I called the licensing commission in California and there's no such thing as a licensed attorney. So you're working off of the basis of constructive fraud here. And I'm not dealing with you. And so you deal with the people, the CEO and different people that you have dealt with. And this is in any case, and anyone that's listening, if this is your mortgage and everything, you are dealing with people because you're a living woman, living man created in God's image, and they have created these corporations all around us to create constructive fraud to control us and everything else. So, okay, on criminal complaint, the date.
right above there is case number. The right-hand top of this AO91 says case number. What do I put in there?
Nothing.
So you don't put any case number because they will create the case number.
Okay. Now down to the criminal complaint section. Thank you.
Okay, so Doug, I don't know the answer to this question. She's asking when they're doing the criminal complaints specifically for a mortgage, is the fraud started the date that she entered into the mortgage or the date that she found out that it was constructive fraud?
Well, the date that she found out there was constructive fraud, because there's no statute of limitations on fraud until you find out. Once you find out, you got 2 years to do something about it, or it's barred by latches. So, you only found out, and I would put that in the criminal complaint that, you know what, I went for all of this time believing that these people were honest and that, they loaned me something. Okay, but I had no idea what a loan was. And once I found out what a loan was, and I found out the true nature of the bank process, the so-called loan process, and the fact that it's nothing but constructive fraud, I have to do something about this because this caused me major harm and injury. I've been paying all my life on a loan that I don't owe. There was never any loan because there was never anything given. I never received a loan, and you can resort to my affidavit and rebut that. You know what I mean?
Oh,
See, everything
okay.
you swear to under penalty of perjury, they have to and rebut, and they have to swear to it under penalty of perjury and give evidence. They have to actually provide evidence. Okay?
Yes, I did all that. I did the affidavit, I defaulted them and confessed acceptance, and then I did the final default too. So, yeah,
I'm just, they can't rebut that. And
Right.
as for the last question, the corporations, look, the corporations, you can go to the legislature and file and try to have their so-called business license removed for constructive fraud and harming one of the people. They can't be allowed to do business in the Republic of California if they're going to continue to harm people, and their procedures and system of constructive fraud causes harm and injury to everybody that they're doing. So you need to remove their so-called license that allows them to practice in California, or we're going to hold you liable.
Okay, so now we're going on to what is appropriate in the titles. I believe this one is relevant because it's deprivation of rights. Title 18, section 242, 241, right?
Yeah, the code section here. So that would be one I would put. And then what about, I forget the title, but I think it's 1341, frauds and swindles. Or go ahead, Madison, you see what I wrote there.
Doug knows those codes way better. When he talks, I write them down really quick. So,
What are the appropriate
Doug,
ones?
what would be the codes for frauds and swindles, and then racketeering? Would it be racketeering or RICO?
Well, RICO is racketeering.
Yeah. Same.
Right. So it'd be under RICO, wouldn't it be titled racketeering?
I think it's 1960. It starts at RICO. Um, what it would be is RICO requires 2 acts within 10 years, and that they profited, that their company or organization profited from racketeering activities, and then they've got a bunch of stuff in the code that they consider racketeering activities: extortion, robbery, bribe, all of that stuff, right? And so, you have to tie all of it in and use the language in your criminal complaint to make it a RICO case, and then or a monopoly case if you're dealing with the courts, uh, or the lawyers. You know what I mean? And I would use like 18 USC 242 is violation of rights under color of law. Okay. 18 USC 241 is conspiring to violate rights under color of law. So, but you gotta actually show the conspiracy, and everything that you do, you have to show in the state, basically in your statement of facts, right? What happened that would cover that violation. You know what I mean? In other
That,
words,
that's easy to do on the sheriff one when I get to that. But for the mortgage one, I think I would do the fraud and swindles is one of them, right?
what you would do 18 USC 1001.
1001? Okay. Not 1341?
Off the top of my head, I don't know what 1341 is.
I think it's fraud and swindles, but maybe not. Maybe I'm wrong. I
Well,
forget.
18 USC 1001 is fraud.
Okay.
And then there's like 18 USC 960 or 960 something, that's emoluments violation. There's extortion, there's treason. I mean, it depends on how hard you want to go.
Well, and that would again be for the sheriff one, but for the banker, would I even put Title 18, 241 and 242?
Well, yeah, they violated your right is not to be defrauded.
Okay.
And then Kathleen, guys, I gotta jump off for like 15 minutes. Do you think you can go through read these next questions to Doug because he can't see them? So the next ones, Doug, are the criminal complaint is based on these facts. So can you ask him and then I'll be right back, guys.
All right, baby girl.
Okay, and you kind of, Doug, already went over this because on my default judgment res judicata, I have a list of like 31 facts. So I would restate those as my statement of facts, correct? And that's the attached sheet that goes with this criminal complaint.
The statement of facts is the first thing out in the complaint. What you're doing is the 801 is just a face sheet. Okay, that's complying with what they require at JAG, at Department of Justice, Civil Rights Division, and at the U.S. Attorney's Office. That's what they require to be able to utilize what Trump put in place for us. So what you do is you do a criminal complaint, right? Without that, put that aside for a minute, and you go get it. You go get that book from Kurt's Law Corner in his library, and it's the treatise on false arrest and false imprisonment. And when you get in there, there's a guy named Charles Weiss that did it, and there's a sample complaint in there. Okay, and that's how you set up a complaint. You do your statement of facts, which is sworn to under penalty of perjury. Then you do the charges, which is what you're putting on the AO 91, and then you do your argument with points and authorities, and that's how you do your criminal complaint. Then when you do it just like that, then you attach the AO-91 to the front of it, and the arrest warrants AO-442s to the back. That's why he put that treatise on false arrest and imprisonment.
But that's not for the bank. So on the criminal complaint is based on the facts, like would I just write in, because this form says the criminal complaint is based on these facts. Would I write in, for
Oh, no,
example, no
you-
evidence of a valid mortgage contract?
You missed my what I was saying. That is for the banks or for anything that you're doing. That is the template on how you set up a criminal complaint. All you're doing is attaching the AO-91 to the front and the AO-442s to the back of the criminal complaint that you set up that way. It doesn't matter. It goes to the bank, it goes to the sheriff. That's just the way you set up the criminal complaint.
Okay, so on this form, I don't have to write anything under that part. I just do my statement of facts in the middle, underneath this form.
And maybe just for clarification, Doug, if I understand, there's a little space on the actual AO-90 form that you can write your complaint, or AO-91, but what you actually want to do is, like with Andy's case, there was a separate document of perhaps 20 pages that
Yeah.
stated it.
That's the criminal complaint right there.
Okay,
All you do
I
is
get it.
thing where you start writing criminal complaint, where they want you to write in that little tiny square. All you do is in big letters go, see attached criminal complaint.
Perfect, thank you. That's what I wanted to know. Okay, and then. Hang on, I lost my question here. Okay. All right, and then when I sign this, it says title. What do I put as a title? Am I a beneficiary or an authorized representative or a Californian, or what do I put there? Thank you.
As a title, yeah, you can put beneficiary if you want, or one of the people, or beneficiary / one of the people, you know.
And Kathleen, you're talking, but you're on mute.
And then I see there's a judge's signature here, but that's not something I do or try and get. That just gets taken care of somewhere else, right?
What happens is this goes before a judge and a court clerk or somebody's clerk, when it goes to JAG or wherever, right? And they put the numbers on it right there, and they get a judge to sign it because it's already, everything's right there. Your sworn testimony to the facts, the argument, how those facts constitute the crimes committed against you, and you're one of the people, and so these people work for you. So you know what? They've got a criminal. They got a crime that's been committed. Here's the evidence of it. It's being committed, and they're being told by an affidavit, which is sworn testimony of one of the people who are actually injured and have firsthand knowledge to it. So, you know, and there's the arrest warrants. There's the people that did it. Okay, so I mean, what is there for them to hesitate? They have everything that they need to act on this. And if they don't act on it, they're guilty of misprision of a felony, treason, emoluments violations, because they're required by their own statutes and codes and by the contract that they signed with us, we the people, in order to hold that job, to execute the duties of that job in that office. So you can go look up the duties of that office, right? And you can see, hey, you're required to do this, 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 and this according to these duties. And you're failing or refusing to do this, 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 and this, and that's an emoluments violation. It's theft and it's unjust enrichment because you're taking money to do this. So,
Okay, then I just have a couple sort of general questions. In my points and authorities, can I use the common law decision of Lenka's court of record as a set precedent?
yeah, but you would have to have a copy.
Okay, so there's no way to like, reference it or, quote it or have any, like, how court cases are used as references all the time.
Yeah, but see, what people get is the only thing that you can utilize out of that case right there, right, according to the Seventh Amendment, is the facts that were determined by the jury of her peers. That there never was a loan, that there, you know what I mean? Those are the things, but see, you're establishing that in your case. Show me the loan.
And you were talking again, Kathleen, but we couldn't hear you.
I keep having to mute so that I can hear Doug, so I apologize. Okay, yeah, no, I understand. Thanks, Doug. That's a good point. Okay, another question, just a general one. The district court is not an Article 3 court, so isn't this another corrupt court? What separates it doing it this way? Is it just the task force Trump set up?
No, you set in place an office, a provisional office or provisional government, okay? Putting in place this consumer protection agency, all right? We're consumers of their corporation at gunpoint, all right? So this was for us to tell on them. This doesn't go to the district court. This goes to the U.S. attorney in the district in which the shit's happening, because the crime's being committed in his district. And so he's in charge of that consumer protection task force. That's how Trump set it up. That's why you go to the U.S. attorney in the district in which it's happening, to the head of the criminal division, and that's who's the head of that task force, because they're criminal complaints.
Okay, understood, makes sense. I just keep looking at the form, so I just want to make sure I understand what I'm doing here. So,
well,
Do you want to show the form real quick? I can put it up on the share just so we can take a look at it. It looks simple, but maybe just seeing it in, hang on one second. Let me just show it here, just so that we have reference of what we've been talking about.
Doesn't do me any good.
It doesn't do Doug any good, but at least Kathleen, for your purposes, if we take a pause back and go through what we've talked about, we talked about how to file this United States of America versus and the defendants. So I think we covered that. Do you have any questions about that particular area of the form?
no, I think we covered all that really well. Yeah, and we got the date really good in the code section. Yeah, I'm comfortable with that now. I'm just sort of asking a couple more.
Okay, then I'll stop sharing and you go back to the asking question.
And I know you guys have talked about this a few times, but I wrote down that you and Madison have mentioned an investigation is to be conducted from this criminal complaint. And so if I understood you correctly, they're going to take this and they're supposed to investigate this complaint I'm making.
Yep.
And do they make us aware they're doing that? Is there any back and forth with us, or is this just sent
No.
into the ether? Yeah, okay.
Look,
In my experience,
here's the
I've just seen people be removed from the bench, removed from office, removed. I mean, the Department of Justice has already put out there that they're investigating the corruption. So I highly doubt it. And here's the thing, in your statement of facts, you're putting all of the evidence, and all of the evidence for everybody is usually on the record somewhere, right? So
well, you know,
That makes sense.
it's it's like this. The statement of facts, um, that right there is basically your sworn testimony, and then the rest of it is basically an explanation how those facts constitute these crimes, and that these behaviors, and these behaviors are crimes according to our foundational documents. But then even your own private corporate policies and statutes and codes consider these to be criminal behavior. Okay, and so you're not telling them, but they're supposed to know that. Okay, okay, check it out. Since now I've brought this before you, and you're receiving a paycheck, and you work for me. You're in a public trust as a trustee, and I'm beneficiary, so you're here to benefit me. Okay, I'm telling you that these crimes took place, and they continue to take place through a system of constructive fraud. And now, under the fact that you have the authority and you're tasked with the investigation or turning this over to the nearest investigative office that's not involved in the crime. Okay, if they don't do that, it becomes misprison of felony. Okay, or misprison of treason, or misprison or what have you. They can get in trouble for that. Usually, what the investigation is they look at it, they look up who you are, they look up the incident that you're talking about, they look at the evidence, they look at what you know, and they take appropriate action from that document that you put before them, because it has everything in it. You're an injured victim with firsthand knowledge who suffered an injury at the hands of an agent of the government or the corporation, and it's based on a system of constructive fraud that they're allowing to continue. Okay, and all of this is getting put before them. So they have a choice, and see, the more that people do this, the less choice they have. You see, because it becomes more apparent that this is affecting a great many people, and everybody knows about it now. And so everybody knows about the fraud. Everybody's going to be doing this, and they're going to be continually doing this until it stops. And it gives Trump an army of we the people who have participated in the taking back of our government.
Yeah.
But you have to comprehend that. That's what people don't understand too. Is we haven't always lived in a republic. The restoration or the reclaiming and standing up of our republics that are here has to be done by people that know how to operate that republic. You know, what good is standing up a republic if you don't know what it is or how to operate it? You're not going to be keeping within the lines and the confines of the originally intended and delegated power and authority. And by doing that, you're crossing the line, and you're doing shit that can get you in trouble. But as long as you're operating the republic in a manner in which it's supposed to be operated, and teaching people how to operate that republic and what's expected, and how to enforce and exercise your right to the republic, well, that's a different story. And that's what we're doing with these criminal complaints and these processes that we're putting out there. We're trying to show people the proper way to be able to stand up to this corporation, exercise their rights, and receive the things that they're guaranteed. You know, the rights, the inalienable rights given to them by God. You know, it's kind of like muscles. If you don't exercise those things and don't stand up for them every day, then they just tend to kind of fade into the past. And that's what's happening now. People have forgot who they are and what rights they have, and how to exercise those rights, and how to be free. So, people are going to have to learn that all over again by standing up and having to fight. And you're in your mind as you put these criminal complaints together, you're learning the law, and you're learning what the rights are, and you're learning how to exercise those rights and enforce those rights against a tyrannical government or tyrannical corporation, or whoever. That's what this whole thing is about. And the more of us that stand up, and the more of us come together and start utilizing these um, tools that Trump and our forefathers have left us, uh, the more that we're going to whip their ass, because they're already scared. There's no way they can stand against it. And this is a worldwide problem. So what we're doing right now is what we're setting down is we're setting down a public record of the corruption and the constructive fraud that's being perpetrated against we the people, in a manner in which, once it's exhausted here, if it doesn't give us the remedy that we want, if Trump's full of shit, and I don't think he is, but if he doesn't do what he's supposed to do, then we can go to the World Justice Court, the common law court of the world, and have a valid claim standing to make that claim.
Such a good
Well,
point.
guys, I don't know if you guys are almost done, but I unfortunately have.
Last question.
Okay,
So,
I'm gonna let you guys go ahead and do that. I'm gonna let Doug answer it. I have got to go take a call for work, and there's an emergency, so I have got to go.
All
thank
right,
you for being
baby.
really nice to talk to you, Madison. I really appreciate your help.
Yeah, absolutely. These are great questions. So I'm excited because I think a lot of people are going to learn. And then, Darcy, when you guys are done, when you show the criminal complaint, will you do me a favor and you can do when I get off, but or Michelle, show the criminal complaint at the top where I'm talking about where the districts of their court of the U.S. attorney, where they have to look, because they will not accept it. They'll just throw it in the trash if that's not on there. So, all right, I'm gonna let you go.
Yeah. Thank you, Madison, very much. And yeah, Michelle will show that the AO 91 again.
All right, bye guys.
All right, bye.
Thank
Okay, the last question, Doug, is, can you hear me? In your experience, what are the possible responses from the defendants when they receive a copy of the criminal complaint with their name on it?
Where do you I've had I've had all kinds of different responses depending on who I sent it to, and where I was at the time. They've got a playbook that they don't deviate too far from. And what they do is, for all this time, they rule by force. Okay. And so they figure, everybody's scared of them. So what we're trying to do is we're trying to put leverage against them. We're trying to scare them and make them worried, because they don't want their corruption coming out, especially the JAG and the Department of Justice Civil Rights Division, when there's a investigation going on. And so, uh, I've seen them get real upset. I've seen them retaliate. Um, I've seen them, you know, come up and try to find out just what the hell it is I was doing. but that was mostly to see if I really knew what I was talking about. And you know, it doesn't matter whatever response they come up with, you're going to have to deal with it. I mean, if you're gonna stand up and fight the system, which is what you're doing, and you know, you're gonna rattle a cage or two, um, especially if you send it to their home address. You know, they get scared. All right, they're not used to having people do this, so they get scared because now people know where they live. Um, who knows who's going to show up? Now they, you know, get upset because you know you've basically interrupted their little dream to where they're untouchable. Nobody knows where they live. They don't have to worry about anything because they're covered. And then when they start getting pressure from above, and when investigations start, they usually get notified that, hey, we got a criminal complaint here that we're looking into, and you know, we may be talking to you, you know, or something like that. They get told that there's a criminal complaint pending against them. So because I mean they have to be insured, and they have to be insurable, right, bondable for them to do what they're doing, or that corporation can suffer. You know, the county of can suffer greatly if they do something and they don't have a bond, or you know what I mean. They're not covered, but only the county is the one that's covered. You know, in any of their bonds. Everybody thinks they have a bond to bond them against, you know, us, so that we can get money or get recompensated, but they don't. Same with the insurance policy. It's only a first party policy. It protects the corporation against anything that their agents do. So, you know, we end up we end up uh, shaking them up a little bit, and the first thing that they like to do is they like to try to, you know, rule by force. You know, they'll call you up, tell you, hey, you can't do that, or they'll respond with documents saying, hey, you can't do that, this and that, this and that. They'll go through 4 or 5 things to get you to, you know, distract you and get you to drop it. But the thing of it is you got time constraints. When you send them something under common law, you got 21. They got 21 days to answer. When they don't answer, that's when you hit them with a notice of default, opportunity to cure, and contest acceptance, giving them 3 days grace. Okay, I'm giving you a 3-day grace period to cure your fault and give me a proper response. Otherwise, should you fail or refuse to respond, failure to rebut is admission, and you will be agreeing, confessing, and stipulating to the following facts. And then you put the facts down there, okay? And the following injuries and crimes committed against me, and you put those down there. All right, so you're giving them a 3-day grace period. That's biblical, and you know you're giving them knowledge and notice of what they're going to be agreeing to if they don't. So when they don't, and you default them, get a default judgment against them, affidavit or notice of default, and default judgment, res judicata, right? Once you've got that against them, they're locked in. All right, they can't do anything about that because, you know, they've had plenty of opportunity, plenty of notice, an opportunity to respond, and a definite explanation of everything as to what kind of crimes or allegations are against them. So you just giving them the process that's due to a public servant before taking action against them. In other words, you've really given them due process, and here's the proof of it. And when you take and attach that to a criminal complaint, it's locked in. It shows that you gave them due process, and they breached their fiduciary duty and didn't cure or correct it when they had an opportunity to, and then you know they were told what they would be agreeing to, and they still refused to do the proper thing and rebut it or make it go away or deal with it in the proper manner. So now, what can they say? Where can they go? What can they do? And then when you short them on top of that, they admit to injuries and damages. So now you have a valid debt against them. You've given them twice the due process, but you gave them a due process on the commercial side to get a valid debt against them before you should try to, and then that allows you to bill them once, first notice, and when they don't pay you, you now have a security interest in being paid on that debt. And here's where the reciprocal lien comes in. And so now you go and place a lien on all of their property and as collateral.
Doug, can I interrupt for a second? It sounded like you said that I can attach my default res judicata, that whole thing. Is that part of the criminal complaint too? Or did I misunderstand?
I, me personally, I like to do things that they just can't get out of. Okay, so what I do is I hit them with a notice of liability or a lawful notification letter, depending on the situation.
Well, I did that whole process. That's like all done.
Well, no, you asked me something, so I'm explaining to you. I like to do that because that right there is documentary evidence that contains the proof that I gave them the process is due to them before taking any criminal or further actions against them. Okay. Plus, they've admitted to all of the crimes and all of the violations and stuff. So what I like to do is I like to finish that process and then attach that to the criminal complaint, so that when I send it in, not only do they have testimony from injured victim with firsthand knowledge as to everything that took place and arrest warrants, but they also have that I before I took this action, I gave them the opportunity to deal with it on their own, and they refused. Okay, and by refusing, they agreed to everything that was in there. So I've got it in black and white that they did all this stuff to me, and they've agreed to it, and I gave them the opportunity to correct it. Okay, when I attach that to the criminal complaint and send it, how can they get out of that? I've got a record of them being noticed of everything. Okay, and as a man, I have a right to hold my own court. See,
Okay.
if we can write a constitution or a contract and allow these people, right, to create a court system, all right, and it's by our authority and through this constitution, if we can delegate that power, we can't delegate power we don't have. Okay, so we have the right and even duty to hold our own court. And holding our own court is going through these processes, like I just explained, all the way through the tort. That whole packet right there is considered your court of record. And then that's what you can bring into our court before a jury to view everything, hear any arguments, give them another chance, and then whatever the facts that are found by that jury can't ever even be reviewed in a court, another court from the United States. Okay, so I mean those facts get locked in, and there's no arguing them. There's no nothing there. Those are res judicata. So that's how we handle our business in a republic. That's us holding our own court when we do our paperwork. Okay, and so that's something we do as men or women sui juris, meaning that we're of age and can handle all of our administrative affairs. These are our administrative affairs. These private administrative claims and the private administrative claims for damages and these criminal complaints. All right, these are all things that we have to be able to do as men and women to be able to claim to be sui juris or sovereign. See? And so when you know this and you start doing this, you hold people accountable to our republic, because that's the only government that we can have. And so they swore an oath, and they're supposed to know the law, and they're supposed to know that we only have one Republican form of government that's allowed and guaranteed. So, you signed up for a Republican form of government. They try to say no. Okay, so you're a corporation posing as government. All right, so you're defrauding the people. by claiming to be government when you're actually a corporation and have no authority at all. Now we get into kidnapping, extortion, unjust enrichment. I mean, just on and on and on. You know what I mean? So these are the reasons that I like to do things a certain way, because I don't like to have them have anything that they might be able to stand on, or they might be able to come back and you know uh, try to find a little loophole or something. There's just no loophole in any of this, and it's based mostly on the maxims of law and the Constitution and foundational documents. And the processes aren't the Bar Association processes. They're common law processes, but they give them the due processes due to them. And what's lovely about it is these attorneys that advise them are so stupid, they've never been taught the law. So when you do this stuff, as long as you follow the process and you complete your stuff on time with due diligence, you've got a court of record that can't be contested. Not by attorneys, not by them, nobody can contest it. They've admitted to it.
It was so funny, Doug. Let me tell you this. I got a letter from the bank president's attorney after I sent the res judicata. And the letter basically said, we don't recognize this default or the opportunity to cure. We don't recognize these at all. It was so funny. I thought, oh, he's uncomfortable. He doesn't know anything.
Yeah, but it's not on him to recognize anything.
I know.
I'd ask him, I'd tell him, look, you're supposed to be an attorney. You're supposed to be knowledgeable at law. So, you don't recognize this because this is real law, common law. It's nature's law. Okay? And if you don't, you're supposed to be licensed to practice law. Well, you know what? If you don't know this, you don't know the law, and what you're selling is constructive fraud. Because you're telling people you know the law, and you said you can't recognize this, or you don't recognize this in your law office. Who gave you the authority or the power to recognize or not recognize nature's law?
Well, and imagine being the guy that owns the bank, paying this bonehead to represent you.
Yeah, but see, I would ask the bank. I would tell them, hey, sir, I know that you and I have differences right now, and I've served you with some type of litigation and notices that you haven't properly answered. But I feel compelled to give you this notice right here, and that is the Bar Association in California was created through Article 6, Section 9 of the 1879 California Constitution. Here's a copy of it. And, in 1960, that Constitution was repealed both by statute and by ballot, thereby repealing the California Bar Association. So, you have somebody on your staff, and they got a state bar number right here, okay, committing constructive fraud against you because he doesn't know the law. He hasn't been able to properly respond to any of the documents that I've sent him, and it locks you in for liability as the CEO or the head of the bank, because you're supposed to know the law and the banking industry and know what a loan is.
That is such a great idea. Yeah.
You know what I mean?
Yeah, that's a really good idea.
And see, here's another thing too. You ought to send a copy to that attorney, and you send them a copy of the little packet that we put together that shows that it's been repealed and has certification from the Secretary of State at that time. So there's no argument to it. And send that to him and see if that lawyer, if he doesn't bring that up and let that be known, that's hiding exculpatory evidence. And that's a felony in California for an officer of the court to hide exculpatory evidence. Like I said, I just like to start shit.
I like it. I do. You and I are cut from a similar cloth because that definitely fires me up thinking about doing that.
Well, yeah, it's like you look at it, right? let's look at this for a second. Okay, we have the evidence in our hand, certified by the Secretary of State from that era, right? The 1879 California Constitution was repealed by deleting certain parts of it as obsolete. Okay, it was repealed. The shit was deleted. It never existed. Okay, so that means that all of the offices that Constitution created don't exist. The Bar Association doesn't exist. The court system that they set up that's operating now doesn't exist and can't exist. Okay, so why mess around? Okay, we've got the evidence of that. So when you put that evidence out there, especially when you put it to the courts, or you have somebody in the court, like an attorney, that doesn't know it, but they're required to know it, what you do is accuse them of knowing it, because being required to know it, knowing it is considered to be the same, right? Ignorance of the law is no excuse. You're saying you're a state bar attorney and you're practicing law. Well, the state bar was repealed. And so I don't see how you can be a state bar attorney, and the licensing agency for California says there's no such thing as a licensed attorney. So therefore you're lying. You see? And that means that this whole court system that was also set up under California Constitution 1879 doesn't exist. You know, what this is a private corporate tribunal created by the Bar Association, who copyrighted all of the law that you're using within this private corporate tribunal for unjust enrichment by trafficking in persons, Part B. Okay? So, you know, when you start getting at them that way, they don't know how to deal with it. How can they deal with it when you've got the evidence that the constitutional authority that they're claiming to be able to act in the manner in which they're acting doesn't exist, hasn't existed since November 8th, 1960. And then these attorneys that are claiming to be attorneys, they hid that exculpatory evidence. Okay, that's exculpatory evidence. That would undo everything that they're doing. Okay, if that was made known. So by them withholding that information, you know, no, oh, we didn't know. Well, ignorance of the law is no excuse. You're required to know, and you're supposed to be a bar member, and belong to that public corporation which was dissolved and repealed. You know what I mean? See, these are the type of things that when you want to really get at them, that's how you start getting at them, and then you push that, like we've been doing. We've been trying to push that for the longest, until you get more people that are aware of it. And once enough people are aware of it, it's going to come to a tipping point to where they can no longer keep this fraud up. You know what I mean? Their court system and everything will come down.
Yeah,
Because nobody will pay any attention to it. If I know for a fact you're not, you know what I mean?
awesome. Thank you so much.
So.
Well, I just want to say thank you so much, Doug, for your time and your wisdom and going through. I know this was sort of elementary to do this one page, but when you sit down to do it the first time and you start looking at it, immediately a bunch of questions pop up as to how to fill in this AO 91. So I really appreciate your patience in going through that with us.
Well, no, it needs to be done. People have to really, you know, it's not so much comprehend, because it's pretty much self-explanatory. But and I know that, you know, that it's hard first time you look at something.
Yeah.
But
That's self-explanatory to you, but us newbies here, until you've done it a couple times, then it's very self-explanatory. But when you first look at it, the questions pop up and you need the answers, at least I do, to feel confident to move forward. So I really
that's the ticket right there. It's what you're talking about, is confidence. See, you have people out there that, you know, they've been fighting, well, they haven't been fighting the system. They've been getting beat up by the system for so long that, you know, it's like a David and Goliath fight, but David doesn't know he's David, and Goliath is pounding the shit out of him. You know what I mean? Everybody's been so beat down by the system that it's hard for them to be able to see that they're more powerful than the system, It's just, it has to be dealt with in certain manners.
Yeah, and your help on this though makes it so that once I understand it, I can duplicate it and help somebody else. You know what I mean?
Right.
And not always you having to answer every single, kind of ridiculously low level question.
Yeah.
Can I ask one question, Doug?
Yeah.
This is the form Madison said to put it up one last time, and I just wanted to do it to show everybody. It's this little section, I believe, right here that she was talking about, where on or about the dates of, and Kathleen had asked earlier, is it the first date, et cetera. But does it matter? Should it be the day, then the month, then the year, or is it month, day, year? Does that matter?
If I do something and it's ongoing, right, I'll start at the date that it started and go still ongoing.
Okay, so you could do like 5th of March, 2023 ongoing, something
Yeah,
like that.
still on.
Okay.
You know what I mean? It's still happening.
And so then in the county, I think Kathleen, for yours, it was San Diego, and I believe you're in the Southern District of
Southern,
California.
and then you put
Yes, although I didn't understand what Madison was saying about the list of persons or something that it's supposed to go to, because I don't see
no,
that.
no, no. What she was talking about is the district that you're in up there, and you're in the Southern District of California, and then it would be the U.S. attorney's name for the head of the criminal division. There is who it goes to.
Yeah, and I think Michelle put that in the chat.
Yeah, and I know I had looked up the Orange County, which fell into Central District, and his name is something else. But I literally just Googled who is the U.S. Attorney for Central District, and so that's all you would have to do. Let's see if I do a Google right now. Who is the U.S. Attorney for Southern District? California, and it comes up with Tara K. McGrath. And I'll copy this and put it in the chat so you've got that, Kathleen.
Of the criminal department, because that was the other qualifier.
The what?
The U.S. Attorney of the Southern District, that's the head of the criminal department, is what you guys said.
On the website for the Southern District U.S. Attorney, right? And it'll pop up, and then it'll be the head of the criminal division that pops up, and then all you have to do is go down in the different divisions that are there. Just hit the criminal division, it'll pop up again, and that's who you send it to.
And then I'm just looking to see. I had to Google a little bit. I think I had to do the address. So it's showing that she got selected in October of 2023. So we know that she's probably not a valid person, yeah, or new. I shouldn't say that. Maybe she is valid. Let's see if I can find the address, comma, address. Southern District of California, contact us, US. Here we go. And I'll just put this in here too. They're down on, I don't know if you need the telephone numbers or not, but we'll put this all in here. Okay, so Tara K. McGrath, and then that is her U.S. Attorney's Office, Southern District, Federal Office Building, 880 Front Street, room 6293,
Yep.
San Diego, and there's some telephone numbers in there too.
Yep.
So that would be the address it's sent to. And then going back to, we talked earlier, here's the area that's kind of, I don't know if it's showing him, it shows light blue for me, but the code section, and then you've got the offense description. And this is where you might just put the C attached complaint, Doug. Would you reference the code right here in this section? Like,
No, I don't.
no,
Code. You put 18 USC 241, if that's the code you're using, and then description of the offense, violation of rights under color of law.
Okay, so right there, it won't let me type it in right now for whatever reason. And then the offense description, is this just an abbreviation? Constructive fraud or,
Well, no, it's a violation of rights under color of law is like 241, I think, or 242, and then
It's
conspiracy to deprive rights is the description. For
rights under color of law. If you put 241, it's conspiracy to violate rights under color of law.
Yep.
You put 1001, it's fraud. Okay. If you put down, I think it's 875, it's extortion. If you put down 960, I can't remember what it is off the top of my head, but it's emoluments violation. See,
so the
that,
point is we want to make sure that the code section, whichever USC you use, 18 dot whatever, it's going to correspond to what the offense is. That's a key element. I just want to make sure this is on the recording for anybody watching. You
Well,
go
Yeah,
back,
that's the description of the code.
right. When
Yep.
you fill out the code, you take the description of the code and put it in that section where it says the description of the offense.
Yep. And then the one below it, it says this criminal complaint is based on these facts. And that's where you write in see attached complaint.
Yeah.
Yep. And then there's a check mark. You probably have to make sure you check that too. Continue down the attached sheet just to make sure nothing gets missed.
Yeah.
And then you've got your complainant signature, your printed name and title, and that goes back to your question, Kathleen, where you'd put
beneficiary, one of the people.
people. And then Doug said not to worry about the sworn to me before. This isn't something that has to be witnessed, Doug. It just goes in with these two things blank at the bottom.
No, you go to a notary republic and you swear on a jurat and put the jurat on the end of that complaint.
Okay, so I don't know that we got that stated earlier. You need a jurat notary attached to this. Is that correct?
It's
Yeah.
the sworn thing at the end of your statement of facts, not this particular page. Maybe there's a little confusion there.
Yeah, you do the statement of facts, okay, and in the statement of facts, you put your declaration or your sworn, where you swear, I swear to this, I will swear to these facts under the penalty of perjury. See attached jurat, and that when you get done, you take the whole thing in, and you have a notary swear you in and do a jurat at the end of it. And then if you really want to get smart, if it says sworn to me before, you get the notary to stamp that. Because that's who you swore to.
And in addition, do the jurat.
You have to do the jurat. The jurat is what the notary puts on the thing that you sworn to. She fills out a jurat in her name.
Right.
That's how you prove you were sworn in. I'm just saying it says sworn to before who? Right there on the front, right? Okay.
Yes.
On 8091. Well, you would put that notary's name because that's whose jurat is at the back. Or if you really wanted to get smart, you could have the notary stamp that.
Okay, so and where it says judge's signature, you could cross that out and say notary signature. Is that what you're saying, Doug? Or no?
No.
No.
No, that goes before a judge. When you send it to JAG, that's who reviews that stuff.
Okay.
A JAG officer or a judge. That's what a JAG officer is. Judge Advocate General.
So we would just write in the notary's name where it says sworn in before me,
Yeah.
signed in my presence. Got it.
No, I think you guys are confused again. The statement of facts is your thing that you want to notarize and swear to, not this form. It doesn't go on this first page. It goes at the end of your statement of facts or points and authorities or the front of it, however you want to do it. But
You put the damn jurat at the end of the at the end of the complaint. Okay. But what you do is right there where it says sworn to before me, or right after the statement of facts, in the statement of facts, how you designate that you only swear to those facts under the penalty of perjury, right? Is by stating at the end of those facts that I do, or the beginning of them, I do swear I am 18 and of age, I'm of age, and I have clear mental clarity or whatever the fuck, and I swear to the following. That's one way to do it. Or you do the statement of facts, and at the statement of facts, you in the caption you put sworn statement of facts, right? And then you go down do your statement of facts, and I so and so do swear that the above facts are true, correct, and complete under the penalty of perjury. Do see attached jurat. So you reference the attached jurat after the statement of facts, stating that you swear to those facts under penalty of perjury. It's the only thing that you've sworn to under penalty of perjury. That's how you designate those from the rest of the complaint.
In this area right here, I don't know if I can draw it or not. It won't let me. I was going to try to just highlight for anybody watching where it says date, city, state, judge's signature, printed name. You leave that blank. That is for the JAG judge. Is that correct, Doug?
Yeah.
Yes.
Okay. So we're
And you might be able to,
aligned.
where it says above here, the attached sheet, maybe that is a place you could put C sworn to that or something in there with my statement of facts, or, you could put it maybe there. If you want to put it on the front page.
You don't have to put it on that front page. You put it at the end of your
No,
statement.
I understand that, but I mean being, that you could put just a notice there, C attached. That's what I meant. I know it doesn't.
What you do is you check it, and it says continued on however many pages, right? Then I would add how many pages it is at the end of it. Here, continued on attached page. I'd put 52 pages or however many pages it is. You know what I mean? But I wouldn't put I mean, you could put see attached pages and or see attached complaint. See, that's where the complaint actually starts. That's just a face sheet right there. That tells the judge that's looking at it who's involved and what they're being accused of, and other information that they need. So the judge looks at it and then flips to the next page, and here's your statement of facts. And he goes on to the statement of facts. He's already read what you're accusing him of. They can tell right there if those statement of facts will equal what you accused him of, and know whether it's either a valid or a fucking frivolous complaint. That's how they judge that complaint.
Okay.
Awesome.
Any last questions, Kathleen? I took the page.
So nice work, both you and Darce. Thanks again for so much help.
Yeah, thanks, everybody. Thanks, Doug. Thanks, Kathleen. And Michelle, thanks for hosting. Really appreciate it.
I'll get the recording and the transcript out to everybody as soon as they finish processing.
Okay.
Awesome.
How do I leave?
You're a
this?
machine.
So there's a red leave button, I think. Find the red leave button, Doug, and you can get out.
At the top right of the screen, Doug, top right.
See you guys, or talk to you guys on Tuesday.
Okay, thanks, Kathleen.